Welcome to today's program titled The Nitty Gritty on COMPS Order number 36. Just how Rockier is it for Colorado employees? At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I'd like to turn it over to Louisa Johnson. You may begin.
Good morning or afternoon, everybody, depending on where you're located. My name is Louisa Johnson, and I'm here with my colleague Jill Porcaro, who's a wage hour lawyer with deep California law expertise. She's now a Colorado resident and is keeping an eye on Colorado law for clients as well. I'm also joined today by my colleague Lennon Haas. Lennon is an attorney in our Atlanta office with me, and he focuses much of his time on wage hour counseling and litigation matters. Lennon will be answering or fielding the questions as they come in from you, and we'll be answering them at the end of this presentation. And again, I'm Louisa Johnson. I'm a partner in our Atlanta office focusing on wage hour counseling and litigation matters. And while I'm resident in Atlanta, my cases and my counseling matters are all over the country. And so that's your team today for this presentation. So we're going to talk today about COMPS Order number 36. COMPS stands for the Colorado Overtime and Minimum Pay Standards Order. The Colorado wage hour law has been around as long as the FLSA. It started in 1938 with the issuance of the first minimum wage order. And when it first started, it was an effort to protect women and children in certain occupations like laundry and things like that. And it didn't change a lot until 1978, when they broadened it to include men as well. And then the changes to it became more frequent, starting with wage order number 22 in 1998. The employers who've been covered by the minimum wage order have been in the retail and service, commercial support services, food and beverage, and health and medical industries. And those four industries were always defined in the minimum wage orders. But there's been a recognition for some time that the restriction of the minimum wage order to certain industries created all sorts of confusion for employers. Employers didn't fit neatly into one of those four buckets necessarily, and there was also a sense of unfairness that, you know, if you were in a certain industry, you didn't have to comply with Colorado law, wage hour law, just the FLSA, Fair Labor Standards Act, federal law instead, whereas in other industries you had to comply with both. And so starting on March 16, just the beginning of this week, they decided to broaden it to include all employers who qualify as employers under the Fair Labor Standards Act definition, which has no minimum number of employees. You can have 2 employees and comply if your annual volume of sales or business done is greater than 500,000. So for all intents and purposes, unless you're a very small employer, you are now covered by Colorado's new Colorado Overtime and Minimum Pay Standards Order, or COMPS Order number 36. So what's changed in the Colorado order? Because we're really talking about 2 things. One, the broadening of the COMPS order from coverage of employers in certain industries to coverage of employers in all industries. But 2, also some changes even for those employers out there who've always had to comply with the Colorado minimum wage orders. So one of the things that's changed, even for those who were already used to the Colorado minimum wage order, is that first by statute and now confirmed through the COMPS order number 36, they have removed the prohibition that used to exist in the law in Colorado on localities setting a higher minimum wage rate. So it used to be whatever Colorado said was the minimum wage rate applied across the state. You wouldn't have a situation like in states like California where localities had higher minimums. Well, that's gone. That prohibition is gone. So you can expect that you may in the coming year see some of the more populated areas where the cost of living is higher, like Denver, go up on their minimum wage rates locally. Another thing that has changed is for everybody, including those who are already subject to the minimum wage order, is a new salary level requirement for exempt employees. So we'll talk about that. And then while meal and rest break requirements may be new for those who weren't subject to the wage order before, even for those already subject to prior wage orders, they may be surprised to hear that there's a new requirement in this COMPS order number 36 that you must pay for missed rest breaks. So for those on the line familiar with California law, up until now, the only place that rules or regulations set forth that express requirement to pay for a missed rest break was in California. And what the COMPS order number 36 has done in a statement of basis and purpose that explains the new wage order is specifically invoke the California Supreme Court's Brinker decision and said, look, you've got to comply with being sure you provide the rest breaks, and if you don't, now you're going to have to pay for it, even though you're already paying for the rest breaks to begin with. So our resident expert, Jill, will discuss that in more detail, but that's one of the key things I want to be sure everybody realizes is changing. And finally, they've gone with a broader definition of time worked that if you compare the language in COMPS order number 36 that defines time worked to the definition in prior minimum wage orders, you'll still see a difference there that suggests it's even broader than it already was. So let's walk through these one by one. One is the overtime requirements for non-exempt employees. The overtime requirements have not changed from prior minimum wage orders, but a piece of them is a bit unusual, and that's the second bullet point here. But before we get into the specifics of the second bullet point, all three of these are ways in which you may be required to pay overtime in Colorado. And I say may because what the regulations say is that you owe whichever pays the most to an employee. So you're not having to double pay time. If you're paying them overtime for more than 12 hours in a workday, you do not have to go back and pay overtime for more than 40 hours per week if paying them for more than 12 hours in a workday already gives them a higher amount of overtime pay for that work week. This second one is kind of tricky, though. It says that you have to pay overtime for 12 consecutive hours of work minus a bona fide meal break, even if those 12 consecutive hours cross over how your company has defined the work day. What does that mean? Well, I'm going to use a hypo to explain this. Assume an employer has defined the workday as running from midnight to 11:59 p.m. and that there are employees working a 12-hour graveyard shift that normally runs from 9 p.m. to 9 a.m. the next day. Assume also that they take a 30-minute meal break, so typically their shift is 11.5 hours, and so you wouldn't have more than 12 hours if they work their normal shift. But what happens if the employee works 2 hours past their normal shift in time, such that they work until 11 a.m. the next day? Well, under the FLSA, and therefore the way most employers would think about this, you would say, well, because we define the workday as ending at midnight, that first day had 3 hours of work time in it, from 9 p.m. to 11:59 p.m. And then that second day of work had the remaining 11 hours in it, from midnight to 11 a.m. And so if you use that definition, because you just thought of Colorado law as saying overtime for more than 12 hours in a day, you would fail to pay overtime you owe, right? But under Colorado's requirement for daily overtime whenever there's more than 12 consecutive hours of work, you owe overtime. And what do you owe? Well, there's 14 hours total of work in this hypothetical. So you're 2 hours over, but you get to reduce it by 30 minutes, assuming that they actually took a completely duty-free bona fide meal break of 30 minutes. So you'd owe an hour and a half, 1.5 hours of overtime under Colorado law using that second overtime requirement of paying overtime for more than 12 consecutive hours. So that's the daily overtime requirement. One of the other things that Colorado law does is that it raised the salary level requirement. And before I get into the specifics of this, I want to explain a little bit of the background here. And this explains why I think there have been changes now. For the first time in Colorado in a very long time, there is a total Democratic control in the governor's office, the House, and the Senate. Those are all Democratic controlled. And as you may remember, back in 2016, there was an effort to change the federal regulations under the Fair Labor Standards Act to raise the minimum salary level for exempt status to $55,000 a year. And that almost took effect until litigation resulted in an injunction. And since then, the new administration has come in and changed the regulations, but setting a lower salary level. Well, the Democratic-controlled government in Colorado disagreed with that and thought that it should have gone up to $55,000 and that made sense. And so they took advantage of the fact that they now had control of everything to go through their own notice of proposed rulemaking and rulemaking process to enact COMPS Order number 36. And so while we're going to be talking about other changes as we go through these slides, I think this was one of the main drivers behind making the changes now. And so that you also know, we've been in touch with the Colorado Chamber of Commerce. I've spoken to some of the leadership there. Their comments focused on trying to fight this increase in the salary level, or at least slow it down to give businesses time to adjust to it. And they were somewhat successful in that, because COMPS Order number 36, as originally drafted, was going to immediately increase the minimum salary level for exempt status to $55,000 a year. Through the comment and process within the rulemaking and the amount of pushback they got from businesses, they've decided instead to do a 4-year phase-in. So, as COMPS Order number 36 was passed, the salary level at present is the same under Colorado law as it is under federal law. Okay, but starting in January of next year, the salary level for exempt status in Colorado, for at least for the traditional white-collar exemptions that we're all familiar with, executive, administrative, professional, that is going to rise to $778.85 per week. And it's important to think about it in terms of a weekly requirement, because it's not enough to just pay the total by the end of the year. You do have to meet that minimum on a weekly or pay period basis. And unlike with the federal law that allows you to count portions, at least a percentage of the bonus towards the salary threshold, Colorado's COMPS Order number 36 does not do that. And so you need to pay as a total cash salary on a weekly or pay period basis the equivalent of $778.85 per week as of January 21. And then each year it's going to go up, and COMPS Order number 36 sets forth the specific amount, so we haven't bothered setting them forth in this slide deck. But the punchline is that as of January 2024, it will be $1,057.69 per week, which is the equivalent of $55,000 per year. After January of 2024, the salary level will increase each year based on the Consumer Price Index. So for those of you familiar with Colorado minimum wage orders, you will know that a new one is published every single year. And one of the things that changes each year is the minimum wage rate on a statewide level. And that's one of the reasons that it's published anew, or the main reason it's published anew every year. Now, everybody will need to look at the new COMPS order every year that a new one is instituted to see what the new salary level will be starting for January of 2025, because it's likely to be something higher than $1,057.69 in 2025. The other important thing here is that there's now, in this new COMPS order number 36, a salary basis requirement. That didn't clearly exist before because there was not even clearly a salary level requirement before under Colorado law. And that salary basis requirement, for anyone who's not familiar with that terminology, what that means is that the salary must be treated as a guarantee for each week the employee performs any work, no matter how little or how much work they do. And there are only a few specifically enumerated exceptions where you are allowed to deduct from that guaranteed salary. And Rule 2.5.1 in COMPS Order number 36 is written a bit in code, but what it says is that the Fair Labor Standards Act salary requirements apply. And the specific section of the federal regulations that the COMPS order cross-references are the ones that set forth the requirement that you pay on a salary basis, and then there's 7 exceptions to that where you can dock someone's pay only in certain circumstances. So those now apply in Colorado. And for anyone whose mind is probably wondering at all times to COVID-19 and how to handle your workforce in these trying times, when they may be taking some time off or not able to work a full schedule, because it's adopted the FLSA salary basis requirements, the same counsel you're getting from your attorneys now about how to reduce employees' pay and maintain their exempt status, those same advice would apply under Colorado law now. Okay, so what about the computer employee exemption? Well, interestingly enough, the computer employee exemption did not clearly exist. There's some argument around some language in prior minimum wage orders that perhaps it did, but it did not clearly exist under the prior minimum wage orders. And for anyone who has worked with the computer employee exemption under federal law, you will know that essentially the computer employee exemption under the FLSA allows you to pay highly skilled technical computer employees either a salary that meets the salary level requirement under federal law or an hourly rate of $27.63 per hour. Now, under federal law, that hourly rate requirement, if you choose to pay on an hourly rather than salary basis to a computer employee, that was created by a 1996 congressional amendment to the Fair Labor Standards Act that created a new Section 13A17. And through the language of that congressional act, it froze the hourly pay at $27.63, which, by the way, at the time was 6.5 times the minimum wage rate at the time, which was $4.25 an hour. And so what Colorado has said is, well, we'll go with $27.63 per hour because we recognize it's not fair to change overnight for our Colorado companies. And so for the year 2020, the computer employee exemption will also be satisfied if you meet the duties test for computer employee exemption and you pay them at least $27.63 per hour. However, starting in 2021, Colorado is probably going to have a higher threshold because Colorado is tying, like its salary, it's tying that hourly rate for the computer employee exemption to the consumer price index. And Colorado noted in its explanation of the new COMPS order number 36 that with inflation, $27.63 now falls below the $55,000 a year, $55,000 a year annual salary that it thinks you should be paying your exempt employees, and it thinks that really you ought not to be able to pay less to a computer employee by paying them on an hourly basis. So it's going to make sure that it is getting, through the CPI adjustments, getting that hourly rate up high enough that it's keeping pace with how you pay salary employees. So for all intents and purposes, computer employees are probably going to need to be paid at least the salary level, even if you choose to pay it on an hourly rather than salary basis going forward. Okay, so what about the other piece of exemption, which is the duties requirement? Because remember, under both federal law and now Colorado law, to be exempt from the minimum wage and overtime pay requirements, you need to pay employees a certain salary threshold. It needs to be a guaranteed salary with the exception of some things like the computer employee exemption where you can pay hourly. But you also need to ensure that the employees are performing certain duties to be exempt. Well, the problem under Colorado law is that the exemptions are not worded entirely the same as they are under the Fair Labor Standards Act. For instance, the administrative exemption under federal law says that it applies to employees who do non-manual work that's related to management policies or general business operations, and who exercise independent judgment and discretion in matters of significance. Well, while the Colorado COMPS Order number 36 incorporates that federal law language, it also says, and the employee needs to be one who, quote, directly serves the executive and regularly performs duties important to the decision-making process of the executive. And it doesn't say an executive, it says the executive. So if you read the language of this exemption and take it at facial value, the administrative exemption is very narrow and covers very few employees in your workforce. I don't think that was well thought through by the Colorado Division of Labor Standards and Statistics. I don't think that was their intended result. But it creates an issue with employers who are trying to figure out how to classify employees in Colorado because there is an argument that it's more narrow. And what is going to aid plaintiffs' attorneys if they decide to make hay over the difference in the language is that COMPS Order number 36 Statement of Basis and Purpose also explains that that Colorado disagrees with the U.S. Supreme Court's Encino decision that came out in 2018. And what the Supreme Court's Encino decision says is that exemptions from the federal law should be given a fair reading, not narrowly construed against exempt status. And Colorado says, well, we don't agree with that. We think that everything should be in favor of employee rights as much as possible. And so we're not going to follow the Supreme Court's guidance on this. We're a state. We don't have to follow the federal law. And for us to be exempt, an employee, we're going to construe those exemptions narrowly. So if you combine that little bit of guidance, which is practically the only guidance we have from the Colorado Division of Labor Standards and Statistics, with the actual language of the administrative exemption, you're in a danger zone where the exempt status of your employees could be challenged by plaintiff's counsel and would have to be worked out through the litigation most likely and court interpretation. And before I move on to the other exemptions, I'll say quickly that the Division of Labor Standards and Statistics historically has not been good on giving guidance. They've never done public opinion letters. They used to do private rulings where if an employer wrote in and said, here's my situation, they would give you a written opinion that applied only to your specific situation and that couldn't be used by other employers in similar circumstances. But now they don't even do the private rulings. And they also used to publish a big book of guidelines as a manual. They posted an announcement in January on their website that they are going to remove that guidance from the website and not provide it anymore. So basically they are, if anything, moving away from providing guidance and giving as little as possible. From my discussions with the Colorado Chamber of Commerce, the unconfirmed suspicion is that they intended for these exemptions to be similar to the Fair Labor Standards Act, and that court decisions interpreting the FLSA will be given some deference. But again, given that they're not following federal law on construing the exemptions fairly, and instead want to construe them narrowly, I can't give you any confidence that a court would stick to interpreting these exemptions the same way under state law as they would under federal law. So talking about the second exemption here on this slide, the executive exemption, this is also similar to the Fair Labor Standards Act, but with one very important exception, and that is that in addition to supervising and managing 2 or more full-time equivalent employees and managing the operations of a company, a division or subdivision, they also need to spend greater than 50% of their work week supervising subordinates. That 50% requirement takes it out of the Fair Labor Standards Act view of primary duty. You know, primary duty under federal law is even if it doesn't take up the vast majority of your time, if it is the key or most important duty that you perform, it is still your primary duty. And Colorado said, nope, we're going to be like California on this. We're going to have a quantitative test. And so the executive needs to have hire and firing authority, be managing a department or a subdivision, and they need to be spending greater than 50% of their time on supervising their subordinates. Another one that's different is the outside sales exemption. This also is harsher than the Fair Labor Standards Act because it requires that 80% of the employee's work time be devoted to activities directly related to their own outside sales. Under federal law, many of you may be familiar with a lot of the pharmaceutical sales rep cases over the years, and the loosening of the requirement in terms of the amount of time needed to be spent physically out of an office or a home office meeting with people in person. Well, that isn't going to fly in Colorado if these exemptions are given a narrow interpretation, because the language requires that 80% of the work time be devoted to activities directly related to their own sales. The learned professional exemption, this one's less concerning because it really does read very similarly to the Fair Labor Standards Act. This is, the exemption that you use for doctors, lawyers, teachers. They need to have advanced learning in science or another learned professional type of exemption, and be customarily and regularly exercising discretion and independent judgment in the performance of their duties that require that advanced degree. What's interesting, though, is that under federal law, there's this separate creative professional exemption. Well, it's entirely missing from COMPS Order number 36. So we do not know whether your graphic designers and musicians and other type of artistic employees who may normally be classified as exempt because of the federal exemption for creative professionals, we don't know if they would be deemed exempt under Colorado law unless you can, through the duties they perform, slot them in to one of the other exemptions like the administrative or executive. And I would think with the graphic designers, if they have a higher level education, you may be able to slot them in there as well. But, my guidance would be to try to make them fit within one of the other exemptions, because we just don't know if Colorado courts are going to say, well, there's no discussion of a creative professional exemption in the COMPS order, and therefore none exist in Colorado. Finally, on this slide, we have the computer employee exemption. I mentioned before that that can be paid on an hourly basis instead of a salary. With respect to duties, however, tracks the language of the Fair Labor Standards Act that requires that you have advanced knowledge from a prolonged course of specialized study, and that you're doing things with respect to networks or software or things of that nature, where you're actually exercising discretion and independent judgment. The difference under Colorado law is, again, this quantitative requirement that you spend 50%, greater than 50% of your work week on the duties that give you your exempt status. Okay, these additional exemptions I don't think warrant a lot of discussion, and I want to get to Jill's presentation of the other issues, but I will just say quickly that there are some interesting ones in here. The one about owners is that those who own 20% or more of an employer who are actively engaged in management are exempt from minimum wage and overtime pay requirements. Also under the same owner exemption is if an employee is working for a nonprofit and they are the highest ranked and highest paid employee of the nonprofit, so basically your executive director, your CEO, that person qualifies as a, quote, owner and falls under this owner's exemption. The only other one on here I think worth spending any time discussing is just quickly the second one for interstate transport workers and government-regulated taxi drivers. A lot of you may have heard of this exemption as the Motor Carrier Act exemption under federal law. The difference under federal law versus Colorado's law on the Motor Carrier Act exemption is that Colorado doesn't expressly have language saying that crossing over state lines meets once every 4 months or so meets that interstate requirement. So basically, if they're not regularly interstate, if it's all pretty much just within the state of Colorado, you may not have exempt status under Colorado law, even though you might still be able to get it under federal law. And with that, Jill, I'm going to turn it over to you to pick up with the second half of the slides.
Thank you so much, Louisa. But before I begin going through the meal and rest breaks, I would like to give out the CLE code for anyone who is on this webinar who would like to get CLE credit. The code is S as in Sam, S as in Sam, 2319. Once again, that's S as in Sam, S as in Sam, 2319. Okay. So the COMPS 36 also contains requirements for meal and rest breaks. And for meal breaks, they require an uninterrupted, completely duty-free meal break of 30 minutes for shifts of more than 5 hours. So duty-free means that exactly what it says has to be completely duty-free. You can't have the employee monitoring the phones, or I know in my experience, there are some employees who carry walkie-talkies who are required to monitor those. There are some who are security personnel who are required to monitor video monitors. If any of that is happening, it's not going to be considered a completely duty-free meal period. The employee has to be able to use the period for personal activities in order for it to qualify as uncompensated time, and that would include going off site if they wanted to. If you put any restrictions on this time at all, it's arguably going to be considered an on-duty meal period for which the employee has to be compensated. Now, there are circumstances when you can have on-duty meal periods, and that is if the nature of the business activity or other circumstances make an uninterrupted meal period impracticable. And that's the only case where you can have an on-duty meal period. And keep in mind that that's going to be construed against the employer. The law also provides for 10-minute rest breaks for each 4-hour shift or major fraction thereof of a 4-hour block, which is going to be essentially anything in excess of 2 hours is a major fraction. New in the COMPS 36 is the failure to authorize and permit rest breaks equal a failure to pay wages. So if you don't give them a rest break, it essentially extends their shift by 10 minutes for each rest period that was required to be authorized and permitted, which means you have to pay them an extra 10 minutes of pay, which is something completely new, as Louisa mentioned earlier, didn't exist before. And so as a practical matter, you would need to consider how you are going to have some kind of reporting system for employees who are actually not able to take a rest break due to work concerns. Then you are going to have a procedure also to make sure that they get paid appropriately in the event that they aren't permitted to take a rest break. Now, the order talks about authorizing and permitting rest breaks, which means you have to have some method to authorize. Usually you have that in your handbook, which says that, we provide meal periods and we provide rest breaks. And then the other end of it is you have to actually allow them to take it, which in certainly be a good idea as a practical matter to train all of your supervisors and also let them know what the ramifications are if they don't allow them to take the rest breaks. Now, as for the meal breaks, they need to be, to the extent practicable, they should start an hour after the beginning of the shift and before the end of the shift. Employees should not be allowed to say, okay, I'm going to miss my 30-minute meal period, and instead I'm going to start work 30 minutes late, or I'm going to skip my meal period and I'm going to leave 30 minutes earlier. They shouldn't be allowed to do that. That could be seen as a violation of COMPS 36. There's some flexibility with the 10-minute requirement under the law. You can split it in half into 2 5-minute breaks given for each 4 hours or major fraction thereof. If the employee agrees and the employee is not coerced to do that. And the 2 5 minutes, it has to be enough to be able to go to the employer's bathroom and return. So if it's not going to be enough to do that, it's not a good idea to split up the time. And you can have an actual written agreement that they're going to split the breaks up with the employee for a period of up to a year. You can also have an exemption to the 10-minute requirement is that collective bargaining agreements can specify any split as so long as the breaks total 10 minutes per 4 hours worked and the employee gets at least 5 minutes of rest for every 4 hours of work. And even if less than 10 minutes authorize and permit applies, and you must pay the additional for already paid rest break time if the employee says they couldn't take it. So the main takeaway from this is that you can have situations where you can have a supervisor who maybe is unfamiliar with the law or, else is having difficulty providing breaks to employees, and you can wind up with a violation for the employees that work for that supervisor for an additional 10 minutes for each rest break that they couldn't take. And that, of course, can add up. Okay, so is this new rest break rule the Colorado equivalent of California's Brinker standard? And that is the California Supreme Court case in Brinker versus Superior Court. And the answer to that is yes. They're essentially following the same standard that says that if an employer asserts that an employee had permission to take a rest period, but in reality the employee was discouraged or unable to do so, then the employer has not authorized or permitted the rest periods. And I can tell you that this is a hotbed of litigation in California where you have employees claiming that the authorization to take a rest period was really a wink and a nod in the handbook, and really the reality was that the employees were not permitted to take their rest breaks. Okay, this rejection of a narrow formalistic interpretation of authorized and permit gives meaning to both permit and authorize. Authorize is the formal permission to take the break, but permitting means that given the realities of the workplace, the employee actually was able to take a break without a repercussion. So a handbook policy or employee schedule is not going to be dispositive that a rest break was authorized and permitted if the employee produces evidence that the realities of the workplace created pressure to forego or practical obstacles to the employee's ability to take a break. So the wording of authorize and permit in the statute actually should be read like a love letter. Both words have significant meaning under this new Colorado law. Okay. Compensable work time. All time performing labor or services for an employer's benefit. This obviously is going to include work that occurs off the clock, and many times this will come up where an employee clocks out and then has to do certain closing activities, or they come into work and they're performing work for the employer prior to clocking in for the day. It also includes time employers require or permit employees on the premises, on duty, or at workstations. So you certainly don't want to have any kind of a requirement in your handbook or anywhere that says that employees are required to arrive to work 5 minutes before their shift starts. I have seen that in employee handbooks, and of course that can be very, very problematic, or that an employee has to be available to work before the shift starts if needed by the employer. So, be careful about those things. If you're going to require the employee to be there before the shift starts, you're going to have to pay them for that time. And so COMPS 36 expressly rejects the Portal-to-Portal Pay Act. And for those of you who are unfamiliar with the Portal-to-Portal Pay Act, what that would provide is that you did not have to compensate for activities that performed by the employee for the benefit of the employer that were preliminary or post-preliminary to the employee's job duties. Compensable time includes donning and doffing of required work clothes. I know that sounds very formal. I thought of that as, you're donning the protective gear, you're doffing the protective gear or work clothes, but essentially anyone putting on any type of work clothes, uniforms, protective gear is going to be considered to be compensable time. At work waiting assignment or when to begin work, if your wait time is compensable. So if you have employees who are, sitting around, waiting for calls to come in, if they're on a queue, or if they're waiting for work to arrive, they have to be paid because they're considered to be under the control of the employer. Also compensable is receiving or sharing any work-related information, and that would include, time when the employee may not necessarily be at the employer's location. So definitely need to be cognizant that it's possible that employees could be performing work when they're at home or when they're not at the work location. You also have to compensate for any cleanup time. So if the employee is out in the field and then comes back and has to wash up, before they leave, certainly you need to compensate them for that time. Any security and safety screenings need to be compensated. So if you have employees who need to undergo things like a security screening before they exit, if they have to go through bag checks or things of that nature before they can exit, those things are going to be compensable. Certainly I've had a number of employers who they lock the door at the end of the shift after the business closes, and they have employees wait to go through a security screening before they exit. That time is going to be considered compensable even if the employee has clocked out. Certainly time spent clocking in and clocking out at the time clock is going to be considered compensable. This comes into play certainly if you have long lines of employees waiting to clock out or clock in to work. So you need to be cognizant if you only have one time clock and it's becoming a problem at the end of the shift that employees have to wait, or in the morning for employees have to wait to clock in at the beginning of a shift, that could be a potential problem that would need to be compensated. And waiting for any of the above is considered to be compensable. Now, the significance of this is there is no de minimis exception under COMPS 36. And de minimis time, although it's recognized under federal law, then is not recognized under Colorado law. De minimis says employers may disregard infrequent or insignificant periods of time beyond the scheduled working hours, which cannot, as a practical matter, be precisely recorded for payroll issues. Okay, and Comp 36 says that this exception has no basis and does not apply to Colorado law for 4 reasons, and because there's no Colorado analog to the federal law. Colorado law requires payment of all wages, and they believe modern technology enables the capture of split-second absurdities. Original de minimis rule was meant to preclude. And once again, the liberal construction of the law in favor of the employees resolves any ambiguity in favor of paying wages. So what does this mean? Well, this means it may not be such a big deal for employees who are clocking in and clocking out because, you can, of course, tell them you are not to clock out until you've performed finished performing work and you're leaving the premises, or tell them not to perform any work if they come in a few minutes early, and it's completely up to them whether or not they want to come in a few minutes early and sit in the break room. But certainly it's going to apply to situations where you have employees who may be reviewing and responding to emails after work. It could apply to situations where you can have a supervisor call an employee after work and maybe spend a couple minutes on the phone just asking some questions. So you have to make sure that you have in your policies that all work is to be compensated, and that you encourage employees that they are to report all time worked, regardless of where that work occurs. So the law does allow certain deductions and, of course, and credits. You can get a lodging credit to the extent that you provide housing for your employee. It can be considered part of the minimum wage paid to that employee. And the circumstances are it has been no greater or smaller than the reasonable and actual cost to the employer of providing the housing, the fair market value of the housing, or $25 per week for a room in a shared residence, dormitory, or hotel, or $100 per week for a private residence in an apartment or a house. And so that's the credit you can take toward the minimum wage. It has to be accepted voluntarily and without coercion, and primarily for the benefit or convenience of the employee rather than the employer. And you also have to have a recorded in a written agreement. You can have it electronically. That states the fact and the amount of the credit, but it doesn't have to be a lease. You can also have a credit, a meal credit is allowed. It should be equal to the reasonable cost or fair market value of the meals provided to the employee. And it may be used as part of the minimum hourly wage. The employer cannot take a profit from it, so you can't include any profit in the reasonable cost or fair market value of the meals that are furnished. And, of course, the employee has to voluntarily accept the meal, meaning that it has to be uncoerced. For uniforms, employers are required to pay for a uniform if they are a particular or special type of uniform, where it's a condition of employment. You have to pay for the cost of purchase, maintenance, and cleaning of the uniforms or special apparel, with exceptions if the uniform furnished by the employer is plain and washable, does not require any special care such as ironing, I would call it wash and wear, dry cleaning or pressing. The employer need not maintain or pay for the cost of cleaning. You don't have to pay for the clothing if it's ordinary, plain, washable, and the employer does not need to furnish it unless a special color, make, pattern, or logo is required. The cost of ordinary wear and tear of a uniform or special apparel should not be deducted from an employee's wages. That doesn't mean that you can't have a requirement that the employee return the uniform if the employee is no longer employed. And keep in mind the donning and doffing compensation that if you require them obviously to put it on at work or take it off, you're going to have to pay for their time doing that. Tip credits. You can have a tip credit of no greater than $3.02 per hour to offset cash wages for employees who are tipped. You must pay a cash wage of at least $8.98 per hour, and you have to make up the difference if the employee's tips combined with the cash wage do not equal the minimum hourly wage. There are new posting requirements. Rule 7.4.1 of COMPS 36 has a one-page poster that must be posted in the worksite. This poster is actually available on the colorado.gov website for the Colorado Department of Labor and Employment section. If you have Spanish-speaking employees, the poster is both in Spanish and English. Distribution of the poster is required if posting is not practicable, if you have employees who work out in the field, who work remotely, you have to give them a copy of the posting. If you have a handbook, manual, or other posted policies or acknowledgement of a handbook, manual, or policy is distributed, the best practice is probably just to distribute a copy of it or attach a copy of it to your handbook. You don't need to distribute the poster when COMPS 36 goes into effect, and it already has. But you do need to distribute if the handbook or manual is updated and the employees are asked to acknowledge the handbook. And it's unclear whether if you distribute it electronically, whether that's going to be sufficient. Of course, if you do post the posting, you need to post it in a conspicuous place. Don't put it on the back of a door, to a closet, or maintenance room. You should probably put it where you put your other postings, usually in your break room, a place where employees frequent, so that they can see it. And Rule 2.2 of COMPS says that exempted positions are not subject to record keeping or any posting requirements. Those are the exempt positions that were just discussed by Louisa in the first half of the presentation. What is the statute of limitations applicable to Comp 36? Meaning, when can employees bring claims for violation? Well, Rule 8.2 provides that a complaint must be registered with the division within 2 years of the violation, except that willful actions may be brought within 3 years after the action. However, there is a prior case decision, Sobolewski versus Baselli and Sons, which suggests that a 6-year statute of limitations exists for a private right of action brought for any violation of the wage orders. So I would suspect that if you are going to the division to bring a claim, they would probably apply the 2-year for non-willful violations and 3 years for willful violations, but if any action that would be brought in court would apply the 6-year statute of limitations. So we are at 58 minutes and 47 seconds. If you need more information or if you have specific credits, if you have specific questions, please contact one of us. We're providing our email addresses here, and we would be happy to assist you. And with that, I will turn over for the last minute to Lennon Haas, who is one of my colleagues, who is an attorney and also very familiar with these issues. Lennon?
Thanks, Jill. We have answered some of the written questions that have come in during the presentation, and the remainder we will also address those But I wanted to say a quick word on some of the issues that can arise given the current situation with the COVID-19 virus. And more specifically, what happens when you've got, say, an exempt employee who can't work because of childcare issues or something like that, or you need to reduce labor costs, and what can you do about that given this new law? And it really depends on a couple things, but the general rule is that if an exempt employee performs any work in a given week, that they're due their salary. This virus, this pandemic situation, it's a fairly unique circumstance, and there is an exception under the FLSA for kind of these unique circumstances. And so if a person doesn't perform any work on a given day, you can, depending on what's in your handbook, if you have a handbook that addresses paid time off, you could potentially ask them to use available paid time off to cover the wages for that day where they did not do any work. The difficulty is that sometimes with these work from home situations, people send a few emails or make a few phone calls, but don't do much more than that. And that's unfortunately probably going to be considered work, and you can't pay for a partial day. So if they've done any work for that day, you're going to have to pay them for that day. But if there is a full day where they don't do work, you can ask them to use that time off, again, depending on what your handbook says, if it gives you that option. And if there is no time off available, paid time off available, you can deduct from their wages in that circumstance. And again, if anyone has any other questions, please feel free to reach out to any of us. We are more than happy, and the few lingering questions that have come up on the chat here, we will reach out to you all individually and answer those. Thank you very, very much.
Yeah, and I want to add one thing about a comment or question that came in about my example of the 12 consecutive hours and the end of the work week. There is no guidance on if the work week has ended and you're working and the employee's working a shift that begins on one night and crosses over into the next day, whether you could say, well, because of the definition of the work week, the 12 consecutive hours rule no longer applies, or yes, it does. There's really no guidance on that. So the most conservative approach would to assume that you still owe that overtime, even though that shift crossed into a second work week. But I think a decent argument could be made that you wouldn't owe for that time because it crosses over the work week. And so if you're encountering this situation, I suggest it's something that you have your counsel help you research some to see if the argument can be made, because otherwise this takes the administrative difficulty of this 12 consecutive hours requirement to yet another level that seems to get into the bit of a ridiculous spot. So certainly something to give a lot of careful thought to rather than rushing to make a decision on one way or the other.
Okay, thank you all so very much. Thank you for your expertise. And ladies and gentlemen, at this time, this does conclude today's webinar, and we thank you so much for attending.